One of the final tenets is judicial review. And the thing about judicial review is it part of the checks and balance system? As you see in the cartoon, it says, I didn't know they were actually serious about the checks and balances on the executive branch. Kind of a fun joke about whether kings or presidents can get all too powerful. Well, one of those powers is the power of judicial review. And this is the last item that is listed on your in your notes. So let's take a look at judicial review. Judicial review, as it says, a sixth principle, is it something that we look at completely independent of the checks and balances? Or is it a checks and do you include it in the checks and balances? You know, it kind of depends on what government book you look at. Some government books list it as a completely separate principle, while others will include it in the checks and balance system. So, you know what? Take it for what it's worth. The definition of checks and balances, or judicial review, I'm sorry, is when you can declare a law unconstitutional. As I said in the previous video, declaring a law, all laws, ordinances, statutes must be in compliance with the federal constitution. The state constitution cannot violate the federal constitution either. So to declare a law unconstitutional simply means that that law is not in alignment with the U.S. Constitution. Who can declare laws unconstitutional? Any federal court. Okay. However, as you can see, the Supreme Court is ultimately the one that has the final say. So a federal court, like the one that we have in Sioux City, can declare a law unconstitutional. But then it more than likely would go to the Court of Appeals, and then ultimately, if the Supreme Court decides that it's necessary, we'll take it and review it as well. The Supreme Court does not listen to all cases. How did the court system get the power of judicial review? Well, if you read Article 3 on the court system, nowhere in the Constitution does it say that the Supreme Court has the power to declare a law unconstitutional. It actually came through a case called Marbury versus Madison. There are several cases here at the beginning of our nation's history that start with the letter M, and at times they can be really tough to put together. But Marbury versus Madison basically happened when John Adams was leaving office and President Jefferson was taking over. At the end of Adams' presidency, he and Jefferson became quite angry towards each other, and that animosity kind of flowed out into their presidency and the way they handled things. As John Adams was leaving office, the night before, he appointed a ton of judges. Those judges ended up being called the Midnight Judges. Well, it was James Madison's job, yes, that's James Madison, the author of the Constitution. It was his job to fill out all of the necessary paperwork and get them delivered. Well, because the Midnight Judges were done at midnight, at the last moment, they did not get all delivered. Marbury did not get his assignment, his paperwork in time, and was denied his job. So Marbury sued Madison for the unlawful, that he didn't get his job as an appointed judge. And it went all the way to the Supreme Court. And what the Supreme Court ruled was that it was under the authority of the president to appoint judges, but the Constitution said they needed to be confirmed. And so Marbury was denied his job. By claiming this power, the judicial branch increased the power of the judges. Because it's nowhere in the Constitution, this power is, of course, seen as an implied power. That power that it comes about because of the Elastic Clause. And the Elastic Clause stretches the power of the government to include things that aren't necessarily instead said specifically. Marbury versus Madison also established the idea of what is a strict constructionalist and one who is a loose constructionalist. A strict constructionalist is a judge who looks at the exact word of the Constitution. There shouldn't be any reading of the line between the lines of this is what the Constitution says, this is what it means. Whereas a loose constructionist will say, hey, let's read between the lines. Look for what is said and not necessarily what is meant. This is where they go to the Federalist Papers and look into the background of what our founding fathers might have meant. This is something that comes down to 2017. A loose constructionalist is often considered a liberal judge and are often appointed by Democratic presidents. A strict constitutionalist is somebody that does not deviate from the Constitution and is often appointed by a conservative or Republican president. This is exactly the standstill between President Trump and former President Obama and the empty space that was left by the death of Justice Scalia. Justice Scalia was a conservative judge, a very conservative judge. And when he died unexpectedly, this opened up the court to be a little bit more loose. Well, because the Senate, controlled by the Republicans, were not going to allow a judge to get in there for life, they held up the confirmation hearing. President Obama appointed 2 other justices to the Supreme Court, both of them considered loose constructionalists or more liberal judges. And so President Trump, we would assume, is probably going to appoint a more strict constructionalist. Okay? All right, we will be returning to this a little bit later in our reviewing. Thanks for watching all of these, and we'll see you in class.